Benny, and the Q&As will be after the three talks. I'm very excited and very honored to present Professor Ernest Weinrib, who is a university professor of law here at the University of Toronto, one of the most influential writers on tort law and corrective justice. His two books, his Heartless books, his idea of private law and corrective justice, and I feel very privileged to have you here. Thank you.
So there's a handout that I hope you have in front of you that's actually repeats the some of the passages that Yuval and Benny talked about, but it would be helpful if you actually had that particular version of the handout.
Yes, 1 second, we have it here.
No, it's a different.
It's circulating.
Good, okay, great, thanks. So let me say from the outset that I think the projected volume that we heard summarized just now constitutes a milestone in the tort analysis as it's directed to Maimonides, and of course there are more general themes as well. And of course I'm delighted that I was such a object of criticism in the extract. I recall what my venerated tax professor once told me when we were studying tax law in law school. He said the next best thing to a gain is a loss for tax purposes. And I think from scholarly purposes, the next best thing to praise is criticism, and perhaps criticism is even better than praise. So I want to direct my remarks to the treatment of corrective justice, in particular that Yuval and Benny also emphasized. So this isn't directed to the entirety of what they include in tort law and what Maimonides included in the Mishnah Torah. It's directed to a particular phenomenon that we can call civil liability, and that excludes ideas of a penalty for purposes of this analysis, and it may exclude some of the other things that were talked about, but that's just to narrow the topic to make it a single phenomenon that we're discussing. So, corrective justice aims to preserve a person's holdings in the face of wrongful transactions. Through the operation of corrective justice, the victim of the wrong, to the extent possible, is placed in the same position at the end of the wrongful transaction and the proceedings that follow from it that he or she was at the beginning. That's and compensation for torts is the expression of corrective justice. So that's just a broad characterization of what I want to talk about. And in my handout, the first passage is actually just an extract from Aristotle's Nicomachean Ethics, in which he discusses corrective justice. And of course, for Aristotle, corrective justice is not the only kind of justice there is. There's also distributive justice. And there's also another form of justice that he calls general justice, which is justice that is aimed at virtue from the standpoint of being other-directed. And all those elements, the corrective justice, the distributive justice, and what is called general justice, are actually present in Maimonides' account, as we just heard. But I want to focus on corrective justice in particular and the context in which it arises. So what Aristotle noticed was that that the operation that I referred to of preserving the preserving the position of the parties at the end of the wrongful transaction as it was at the beginning, that operation has a distinctive normative structure. It's a distinctive mode of thinking in bipolar relationships that treats the parties' relationship as a normative unit that has its own internal normative character. And this is what Aristotle is describing in these few lines. I've just extracted from him. It's that justice is in transactions, as he calls it, that is in these bipolar relationships, involves a notion of equality, a particular notion of equality. And we can think of this notion of equality, if I could paraphrase them a bit, as on the one hand negatively implying that there are no one-sided considerations that are relevant. That is, within the transaction, within the relationship of the parties, the normative considerations that are applicable are actually relational, not skewed to one party or the other. And so that's expressed negatively through this idea of equality. It's also expressed positively through the idea of relativity. That is, we always consider the parties in relation to each other. Now, at least in my understanding, this idea of corrective justice is not consequentialist. That is, it's not trying to achieve any independently desirable goal, such as, say, economic efficiency. It's concerned with justice as an internal normative quality of the relationship. I think that's what Aristotle was trying to set forward. And it's worth, I suppose, also remarking in this context that until modern times, this structure of understanding civil liability was, so far as I know, the only game in town. There was nothing else. It was, but all the other developments that characterize tort law, including some of the ones that were mentioned in the first presentation, all those are the intellectual inheritance of utilitarianism and related objects. And so I think historically it would be very odd if Maimonides somehow shaved Aristotle off in order to introduce any version of Bentham. But that's just a historical observation. That doesn't actually go to anything of substance on the matters that were mentioned. And this idea of corrective justice is reflected in the third extract on the page. These extracts I've just taken from Benny and Yuval's work. I've expanded them a bit. From Hilchot Niskei Mamon, whenever a person must pay full damages, the payment is considered to be a monetary obligation that he is liable to pay, as if he had borrowed money from the other. This is the obligation. This is the principle. Whoever pays for the damage that he has caused, it is considered a monetary obligation. Whoever pays more or less, the double payment for theft and so on, is considered a fine. So corrective justice is a theory about what, in this passage, is termed a monetary obligation. It's a theory of the relationship that leads to that monetary obligation. And that seems to be, as Benny and Yuval note, in keeping with corrective justice, the Aristotelian version, which, as I say, is presumably the only thing that Aristotle had, that Maimonides had to go on, and which he must have been familiar with as well. Now, in this, on this issue, it seems to me that the crucial text is text number 2, which were referred to earlier. The commandments comprised in the 5th class are those that are enumerated in the Book of Torts, the Sefer Nezikin. All of them are concerned with the removal of wrong and the prevention of damages. I think this is actually a crucial text. It's a crucial text for you, as you mentioned. I think it's a crucial text. And the interpretation that Benny and Yuval give to this text is that there are 2 objectives, or 2, as they put them, meta-aims. The first is the removal of a wrong, which is corrective justice, and the second is the prevention of damage. And that's because the first looks back to the wrong being committed, the second is anticipatory, looking forward. I think this is not actually a proper interpretation of corrective justice. Let me just go back to what I said a moment ago. Corrective justice is a mode of thinking about the relationship. From the standpoint of that mode of thinking, it doesn't matter whether it's corrective or prospective. The question is, how does a person stand with respect to the existence or the prospect of a wrongful transaction? And so the question is the norm that's being asserted, is that an embodiment of corrective justice? How the legal system reacts to that, to the either retrospective or prospective violation of that norm, doesn't change the kind of norm it is or the kind of justice that's applicable. Let me give a modern example. Let's say there's an existence of a nuisance, and in which the plaintiff, the person suffering the nuisance, gets monetary damages for the damages he suffered up to that point, and an injunction to prevent further damage. And let's also assume that the rules of nuisance law can be accounted for through corrective justice. This is something that I've written about, of course, not in connection with Maimonides, but in connection with contemporary law. So it's a corrective justice norm that has this remedy that is bifurcated into the past and the future. Are there 2 forms of justice here? This is just the same idea of justice. One is retrospective, one is prospective. But the underlying idea of justice has not changed. That is, I think, that it's not correct to say that corrective justice is retrospective only. Corrective justice is a mode of thinking that can be retrospective, can be prospective. It tells us what the nature of the wrongful transaction is, that's all. So I wouldn't attach the significance to that bifurcation in Guide 340 that Benny and Yuval attach, because I think that distinction is against a background of corrective justice. That is, these are, whether it's prospective or retrospective, isn't significant. I'll come back to the injunction example in a moment. Now, when Benny and Yuval talk about the prospective significance, they say this is a matter of deterrence. That is, we want to deter the parties. We want to deter the defendant. We want to deter the wrongdoer. And from that, they analyze the deterrence as deterrence in the name of economic efficiency, using Guido Calabresi's idea of cheapest cost avoidance. And I think that is also making an unnecessary assumption. That is, that deterrence is a lead-in to the market deterrence of that they then want to invoke. Deterrence can have different forms. There can be economic deterrence, and that's been the subject of much tort theory, much writing. among tort theorists. But there's another form of deterrence that is also possible. And that is, one can deter in order to achieve corrective justice itself. Or one can deter in order to achieve the integrity of the system of liability and of the set of corrective justice norms. That kind of deterrence is, of course, completely consistent with corrective justice. That actually is corrective justice, just in its prospective aspect. And one aspect of that is kind of deterrence is to make sure that legal norms, which gets assumed, are on the basis of corrective justice, are treated as norms. That is, they're treated as norms that have to be adhered to. They're not treated as recommendations. And they're not treated as options. That is, you can or you can't. And they don't give rise to a system of prices. That is, oh, I can do this if I'm willing to pay the price. And the legal system, especially a system that's in its civil liability domain, involves corrective justice, can indeed must recognize that form of deterrence, not the form of deterrence that Benny and Yuval are talking about, but that particular form of deterrence. Now, let me go to three passages that they mentioned and are crucial to their argument, for which I'm going to offer a different view. So one is paragraph 4, number 4 on my list. So this is the section that deals with settling the amount that the owner of the animal has to pay if the animal has grazed on another's property. Right, the Talmud says, right, pays what it benefited. And the question is, how is that computed? Now, the idea of paying for what it benefited, the owner paying for what it benefited, that is a purely corrective justice idea. The question now is, how do we compute, how do we quantify what the payment is? And here the question is, in the Maimonidean passage, and of course this has earlier roots, do we look upon what the animal has eaten as a self-sufficient unit, or as part of a wider whole? And if so, how wide? That is, do we look at just this, or do we look at this in the context of neighboring fields, and how much? And Maimonides' point is that the narrower we look, the more favorable it is to the plaintiff. And the wider we look, the more favorable it is to the defendant. Corrective justice would require that we adopt a position that is not antecedently favorable either to the defendant or to the plaintiff. We have to adopt some intermediate position. That's corrective justice. There's nothing distributive about this. And what the Maimonides says is that the width of this, the use of the number 60, comes to bridge, as he says, this is between the victim and the perpetrator. That is, it doesn't bridge in the sense of dividing anything. There's nothing being divided here. What it bridges, the way it bridges, is that it tries to get a measure of quantification that is antecedently fair to both parties, not unilaterally favorable to either party. This is just classic corrective justice. There is nothing distributive about this. This is actually what corrective justice requires. Then we have sections 5 and 6, passages 5 and 6, that are passages that involve deterrence. But notice the kind of deterrence that is being talked about. This is not deterrence in the name of cheapest cost avoidance or in the name of efficiency. This is deterrence in the name of the integrity of the legal system. In 6, for instance, this a statement that the payment, if it's made in terms of real estate, has to be from the choice field and the choice vineyard, as the Torah says. And Maimonides comments, for the sake of repair of the world, the victim will collect his damages from the best of what the perpetrator has, in order that damages and domination will not increase among people. This is a statement of the integrity of the legal system as preventing damages and domination in the spectrum of possible ways of computing the amount of land. Non-consensual wrongs have a special place. That's in effect what the Mishnah that he's commenting on tells us. And this special place is to prevent damages and domination. Again, this is a kind of deterrence that is systemic to the system, that is not concerned with economic efficiency, and that is required, not only consistent with, but actually required by corrective justice, if the corrective justice norm is to be treated as a norm. And I think that's even clearer in passage 5, the passage of the animal that's pasturing, and the owner is given a warning on 3 occasions, and the animal doesn't do anything. The animal comes onto the field. The owner of the field has the right to slaughter the animal in a ritually accepted manner, that is, to slaughter the animal in a way that does not minimize the value of the animal, does not inflict gratuitous damage on the owner of the animal, and tell its owners, come and sell your meat. The rationale is that it is forbidden for a person to cause damages and then to pay for the damages and cost. So I think this seems to me to be a clear statement that a legal norm is not an option. That is, a legal norm is not an invitation to breach it and then pay the damages. The legal norm has to be observed. It's not a price. It's not an option. I think the economic analysis that you refer to has certain difficulties about this specific point, because in the nature of the matter, economic analysis can't tell the difference between a price and a norm and a remedy. Here, this is just a vindication of the role of law in preventing what would be corrective justice, the breach of corrective justice norms. So there's nothing inconsistent with it. That makes me sound very defensive. This is a vindication of corrective justice. The very passage that Benny and Yuval think was fatal to corrective justice is actually a vindication of it. And I think that applies to the other passages that I've mentioned that play a central role in their argument. What I've tried to do is to make reference to the passages that they make references to. Those of you who know me know I'm not in the Maimonides game, I'm in the legal theory game. To make reference to the passages that they refer to, and to try to show that the conclusions that they draw from these passages are, I think, not the most plausible, and that it's not plausible to view Maimonides as being not a follower of Aristotle on these, but a precursor of Guido Calabresi. That probably is not the best way to look at these passages. Anyway, thanks very much.